Yeah, thanks very much for going along. Apologies in advance that we weren't able to do this much earlier, but travel logistics being what they were, George and Gatwick left Scotland today at 12 o'clock, and this was the earliest really in fact we could do this, so apologies in advance. So I am going to give an indication about the nature of the legal case that is arising from George and Gatwick's ordeal over the weekend at the hands of the police at Gatwick Airport, and then each of them will be happy to speak to you and give an indication of where they're at following what happened on Saturday morning through into the afternoon. So we act on behalf of George and Gatwick, both of whom were detained on the 27th of September for approximately 4 to 5 hours, respectively. They were returning on a flight from Dubai when they were confronted by armed police officers, citing Schedule 3 of the Counter-Terrorism and Border Security Act 2019, and they cited that as the basis for the detention. Now, as a preliminary, I think it's important to record that neither George or Gatwick were formally arrested as such. Rather, they were detained for the purposes of what was called an examination. During the course of their ordeal, they were subjected to a frightening interrogation procedure, and that was conducted by armed police officers who proceeded to ask them questions which at times ranged from the sublime to the outright ridiculous, including queries about China, Gaza, and Russia. On any analysis of such questioning, there was nothing put to them which could remotely be described as evidence of any form of hostile activity. And hostile activity is the key word underpinning detentions under Schedule 3 of this draconian legislation. And we can state with some confidence that none of the questions posed had anything whatsoever to do with terrorism. The operation of Schedule 3 on the index legislation is both draconian and oppressive, and it's aimed at subjects who present as risks to the state. Given the facts of this case, as I've unfolded to date, it's clear that this was a contrived, politically motivated investigation, and it was undertaken with the aim of humiliating, undermining, and ultimately embarrassing each of my clients. It served to cause much distress and anxiety, not only for them, but also their family and close friends and colleagues. To compound their trauma, although police will probably say otherwise, they didn't in fact have access to a lawyer of their choosing. And this is very important because of the serious implications arising in the event that any person detained under these provisions refuses to answer questions. And if that course was taken, no matter how seemingly banal or otherwise irrelevant, it would have devastating consequences. While the right to silence is technically preserved here in the anomalous outworkings of Schedule 3, it serves in many ways to effectively erode that inalienable right to silence. Unlike other mainstream policing investigations, where silence alone can never be used of itself to ground a criminal prosecution, if you say nothing in a Schedule 3 examination, you run the real risk that your silence will be used disproportionately to prosecute even with the flimsiest of other evidence. Such barely credible corroborating evidence could be something as simple as travel to Moscow. You stay silent at your peril under Schedule 3. It makes it all the more concerning then that when you look at the failure of the interviewers to inform George and his wife had in fact been detained as well, given his belief that she was seeking access to legal advice for him. After consultation with each of my clients today, I have little doubt that had Mr. and Mrs. Galloway declined to answer questions, they would have run the serious risk of being subjected to the most egregiously contrived prosecutions under Schedule 3. In that event, not only would they have lost the right to travel freely, but they would have run the risk of being deprived of their liberty. Notwithstanding all of this, they were deprived of legal advice. Each of them still answered questions put to them throughout the entire detention. The entire operation went well beyond the scope of police powers under Schedule 3, as it was plainly no lawful basis to detain nor by any stretch of the imagination could there have been deemed to be any reasonable suspicion of engagement in so-called politically hostile activities. This was a barely concealed ruse to get their phones and their IT equipment. Our client's most immediate legal remedy is a challenge both to the decision to implement their detention and the ongoing investigation against them. As part of the case, we will be seeking access to all records and authorisations relating to the detention and indeed the precise legal basis upon which they were deprived of their liberty. Equally, we demand the immediate return of their mobile phone and laptops, all of which contain highly sensitive communications relating to their work and engagement with many agencies, including, indeed, the British government itself. Today, we're issuing pre-action protocol correspondence against the relevant agencies engaged in the operation, which was overseen by Counter-Terrorism Policing South East. It remains unclear who exactly was ultimately responsible for overall decision making, but that will emerge shortly in the course of this legal action. On the technicals, we are citing breaches of Articles 5, 8, 10 and 11 of the European Convention of Human Rights in relation to our respective clients' rights to liberty and security, respect for their private life and family life, together with freedom of expression and association. Given the status of one of the interviewers identifying himself as connected to the security service, there is a wider discrete issue pointing to the likely involvement of the intelligence agencies. On the basis of this suspicion, we are considering filing an application to the Investigatory Powers Tribunal in order to assess the extent to which MI5, MI6, or indeed any other intelligence agency had a hand in this investigation. Standing back and looking holistically on what transpired on Saturday, together with our awareness of recent spying revelations and journalists in this jurisdiction, we cannot discount the real possibility that Mr. and Mrs. Galloway equally have been the subject of directed surveillance by state intelligence agencies. Both Mr. and Mrs. Galloway were the victims of a cynical, intelligence-led and politically motivated operation of Orwellian proportions. It was specifically designed to access their private data and communications as some form of phishing exercise. More generally, it was initiated to undermine their integrity and credibility by seeking to demonise and marginalise them. However, history has shown that whenever the heavy hand of the state weighs down on its citizens, that only serves to galvanise victims into even greater resolve to challenge and agitate against injustice. As evidence of that, we need look no further than the recent exposing of industrial-scale spying operations on journalists and indeed lawyers in this jurisdiction over the recent number of years. We're confident the brave stance taken by George and Gatwick Galloway in legally challenging the abuse of power perpetrated on them at the weekend will equally reap an important dividend. In their case, it's the hard-fought right and liberty to hold and promote independent political views and thoughts. Saturday's state machinations amounted to the most egregious attempt to erode freedom of speech and freedom of expression. Our client's pending legal battle starts today, and it transcends both their own case and also it ought to put a marker down against the oppressiveness of the operation of Schedule 3. Today's legal action has to serve as a precedent to rail against the legislation being used as a sledgehammer to silence any form of political dissent. Detaining George Galloway in a bid to try and silence him because robustly expressed political views which are in many ways uncomfortable to those in authority will simply fail. If nothing else, it'll only serve to redouble its efforts. He fully expects that those who planned Saturday's actions ought to rue the day that they did so. Thank you very much. I'll just hand over now to George to respond.
Well, thank you, Kevin, and thank you, ladies and gentlemen, for coming to this press conference. At least at first, I want you to separate me from this issue speak because I'm well aware that my views are a minority taste. I don't pretend to speak for the majority, though I insist that I speak for a sizable minority on British state policy towards many things, but in this case, international issues. I want to separate it because in this press release is the use of the word Orwellian. This was an Orwellian experience. I invite you and all citizens to contemplate the meaning of the phrase, "You are not under arrest, but you are not free to leave." You have no right to silence. If you refuse to answer any and all of our questions, you will automatically be committing an offence under the Act, the Terrorism Act, albeit Schedule 3 of it. I've been around the block, but I never expected such words to be addressed to me. The doublespeak in the phrase, "You are not under arrest, you are not free to leave," is one that chills or ought to chill the blood, and it could happen to any of you. I am nowadays a broadcaster with a very significant audience. I was abroad before returning to London, Gatwick, as a broadcaster, speaking on media matters, in particular the looming presence of AI in the lives of broadcasting and journalism. This could happen to any of you. You could be told, you're not under arrest, but you are not free to leave, and that you have a legal obligation to answer any and all questions. And in the context, Mr. Winter mentioned some of them in this jurisdiction, but across the United Kingdom as a whole, we now are poised to enter into an enormous battle over the question of digital ID, where almost 3 million people in less than 48 hours have signed a petition in opposition to this. Going to be the hottest of political potatoes. It's going to be a poll tax moment for the government, in my opinion. With the spying on journalists, spying on lawyers, repeated arrests at British airports of British journalists like former Ambassador Craig Murray, Richard Medhurst, Kit Clarenberg, and others. This is all a sign, an indication of a vortex into which our country has fallen, in which freedom of speech, freedom of expression is increasingly threatened, impelled, actually, such that even Donald Trump, of all people, felt able to cite it in the presence of the King himself during the recent state visit. Vice President J.D. Vance has been at loggerheads now for 8 months with British laws which impinge upon the freedom of expression and speech of American-owned tech companies like X and Google and so on. We really are heading into a dark place in this country. Not to mention, almost 1,000 arrests made, primarily of old age pensioners, sometimes of octogenarians, in 2 cases of people in their 90s, blind people, disabled people, members of the clergy being arrested under the terrorism laws for holding a cardboard placard at protests in England and elsewhere. latest one being this morning outside the Labour conference in Liverpool. But I feel that in what they did to us, they pushed the envelope further than they have ever done before. It's one thing detaining, arresting journalists, but in my case, as a 7 times elected British Member of Parliament who sat through the passage of the Terrorism Act and opposed it line by line, not knowing that one day it would be used against me, it seemed to me like a crossing of a Rubicon. I'm the leader of a British political party with hundreds of thousands of votes. I was last elected to the British Parliament only last year. Who knows, I might be elected again. Suitable by-election arises. I'm not an unknown person. They must have known, whoever designed this, that this was going to become a very big issue indeed. And it has. And not just here. The Chinese Foreign Ministry have, just in the last few hours, expressed their concern about it. And it has excited comment from Rio de Janeiro to everywhere else around the world. I'm receiving requests for interviews from literally all over the world. And they must have known that that would happen, or they're too stupid to be in the security services. So, to the event itself, I can confidently say, having been robustly interviewed by journalists all of my life almost, this was no interview. None of the questions was specific in any way. I fully expected to be asked about something I'd done. I was not. I expected to be asked about something I'd said. I was not. Something I'd written. I was not. No specific question at all was asked of me beyond generic musings that I now believe were merely a pretext for, as Mr. Winter said, the seizing of our devices to go on a fishing expedition for morsels, the delectation of the government, or for feeding to the media, or for potential prosecution on non-security, non-terrorist issues. The use of such a terrifying procedure to obtain access to material that they would never otherwise be able to obtain, because of course it sought a warrant to require our computers. The judge would have asked, what's the basis of your request for a warrant? And they would not have been able to give one. They had any evidence that my wife or I had ever committed any criminal offence, they would have questioned us ordinarily and normally about that. But the beauty of this schedule in this act at a port for them was that they had no need to show cause. They had no need to give a reason why they were seizing our material. And that's a lacune in British law that I certainly had underestimated. It stopped them at a port under this legislation, and that cannot possibly be just, cannot possibly be morally correct, and we intend to prove it cannot possibly comply with our commitments under the European Convention of Human Rights. I do need to stress that we were not, or I was not even detained. I'll come to that in a minute. But I was not asked a single question about anything I had ever done, said, written, or otherwise expressed. And I formed the view, the police have said today in their response, we were briefly detained. We were not charged, and we were allowed to proceed on our way. Well, it depends what you mean by briefly. 4 and 5 hours didn't feel at all brief. And of course, we were allowed to go on our way, minus any means of communicating with anyone. Lawyers, family members, followers, friends, no one. We arrived from the airport to London for the long train journey to Scotland in a black hole. Nobody knew where we had been all that day. Nobody knew why I had not turned up for the speech I was to give in London, in central London, ironically in the presence of the Chinese ambassador. He thought I'd stood him up, and I had no means of communicating to the organisers of the speech, the event, the meeting, and therefore they were left to imagine I had disappeared into some kind of black hole, as were our children, as was my 90-year-old mother. Nobody knew where we were. If we had disappeared into the Bermuda Triangle. Now, we are meeting this robustly. If they imagine that this would intimidate us into silence or pulling our punches, then, as I say, they're too stupid to be in the security services. But we, for the sake of liberty in this country, are determined to pursue this all the way to the end. The only last thing I'd say, Kevin, and it's quite a significant thing, I said to the police officer, you have behaved dishonourably in this regard. The police were otherwise, apart from this, perfectly polite and courteous to me. But in this regard, by omission, they dishonourably and disadvantageously from our point of view, did not tell me that my wife was in the very next room being held under the same clause of the same act. Why was this important? Because I immediately asked them to inform my solicitor. They claimed that they could not get hold of my solicitor. They offered me a solicitor of their choosing. I declined on the basis that my wife was now outside of the airport contacting my solicitor directly. Little did I know that she and her devices were in the next room and being held. Now, I don't mean to sound in any way patronizing. You can imagine that I have got under the skin of successive British administrations. You can imagine that I am not liked in the security services. But what has my wife ever done? She's not even British. What has she ever done to be detained for 1 hour longer than me? Myself 4 hours, her 5 hours. What has she ever done, ever said, that could in any way, reasonably, and the law must not be arbitrary, it must not be deployed on the basis of protected characteristics.